I am here with Jay Levine from Levine Law. Now, I have run into an issue with one of my associations. They've come to me and asked me, we have a unit owner who's not paying their assessments and is saying because our covenants are 30 years old, they can't be enforced and they don't have to pay their assessments. Can you elaborate on that?
Right. Well, let me first tell you who is not to be concerned with that and who is. Condominiums do not have a concern. And the reason is that the legal description in a condominium deed is the OR book and page of the Declaration of Condominium. As long as the legal description cites the property OR book and page of the restrictions, you don't have a problem under the Market Record Title Act. The problem is for HOAs, Homeowners Associations, because the typical HOA deed is plat book and page. The plat book and page is not where the restrictions are found. They're found in a separate document called Declaration of Restrictions. Those are the associations with the problem. Once a declaration is more than 30 years old, it doesn't mean every lot within the association is now unbound. It's a lot by lot analysis. And what I have to do, and this is confusing to even lawyers who even dabble in this, is you go back 30 years, and then you keep going back until you find the root of title. That's what you're searching for, is the root of title. If the root of title is usually a deed. So let's assume you go back 31 years, you find the deed. If the declaration is older, now that's a concern. But that doesn't mean you're SOL. What you do is you start with the root of title. Does the root reference that declaration by book and page, or even by name? If it just says subject to restrictions of record, not enough. If it says subject to the declaration of Sandtree, that's enough. That lot is still bound. As years go on, more and more lots fall out. And there's a process you have to go through. The better process is don't wait past year 30. Do it at year 28, 29. If you do it less than 30 years old, that's called, it's not your issue of the lots falling out, but you preserve them for another 30 years. The preservation process is easier because it's a board decision. There's a mailing to the owners, certain document collection you have to send to the members so they're aware of what you're preserving. But then the board votes, you file a notice of preservation, you're good. Once you hit 30 years and a day, you can no longer preserve. Even though no lot fell out yet, because the conveyances sometimes go over a time frame. So the roots are going to be at different intervals as people buy from the developer. If the developer had the foresight, and developers often didn't, especially back then, to recite the declaration in each deed, that would have helped that association. That's not the way it normally happens, and in the title business, it's just plat book and page. So that's the concern you have when the documents are over 30 years. Now, what does that mean in practicality? If a declaration no longer applies to that lot, that owner does not have to pay assessments, because the obligation to pay assessments flows out of the declaration restrictions. It doesn't mean there might not be an equitable argument, that equitably you're getting a benefit. We're paying for your insurance, we're paying to upkeep the grounds, you're getting an economic benefit, so you should equitably pay something, whether it's the same amount of assessments or potentially something less. Same with access. Their rights of ingress and egress flow out of the documents. Are they now going to be landlocked and they can't go to their property? So that's going to be an issue. And then the restricted uses, pets, vehicles, leasing, things like that, that clearly would not apply if that lot is out. So when we are asked to collect an assessment or enforce a provision in the documents, when the documents are older than 30 years, I have to do what I call a Market Record Title Act deed search to see if that lot happens to still be in the fold or the lot fall out.
And what can the association do or other homeowners do if one has fallen out and is using that against the association? Does the association need to sue because they're receiving benefits the homeowner is?
Well, more important is you need to address the fact that your documents need to be revived, and you need to do the proper work that's necessary to keep those covenants in place. I believe the board has a fiduciary duty to ensure that you have an enforceable set of documents. And if a document is so old that lot by lot's coming out, I believe the board has a duty to try to get this process completed. Now, when you're past 30 years, it's not just a board decision, it takes a member vote now. And it's a majority of all the lots. Even though the documents may be amended by a higher percentage, the statute says it's a majority of the members to agree that you're going to keep those documents in force.
Even if it's been after 30 years?
Yes, right.
Okay.
It's called revitalization. See, preservationists preserve them from going away, revitalize, almost like the patient is on life support and you have to revive the patient. You have to determine who the record owners are in sending the mailing to the owners. So I don't think the board has a choice. I'm finding a lot of boards resist because of the cost, and I think those boards are doing a disservice to their members and potentially creating liability because people are now not having to pay assessments. And I'm not aware of a court case that got into, okay, if they're not bound to the declaration, equitably, what do they owe? And you may be a case of first impression and spending a lot of money on multiple fronts as different owners find out that maybe they're out. At some point, it's way less expensive to just revitalize the documents. And for the most part, you will get the majority of the members seeing the benefit of an association and the restrictions and want to keep things intact. And so the chances of a positive vote is likely.